Start. All right, ladies and gentlemen, I don't know how many ladies we have on the call this morning, but irrespective of the number, I just want to say thank you, ladies, and also thank you, gentlemen, for joining our section today. I know, Ado, you are there. I don't know if we have other, female there, but everyone, thank you for sparing the time. On a Saturday morning in the UK, and if you're joining from Nigeria or any other part of the world, thank you also for taking the time, to be part of this webinar. All right, so this is one of our webinars anyway, as one of our monthly webinars. So as a business, we try as much as possible to keep you updated with trend in the marketplace, what is happening, with new technology, regulations and everything that you think that is happening out there, we have it covered here at Smart Learning. And we're so excited today, to bring you or to be discussing this topic, okay, which is the Nigerian Data Protection Regulation versus the EU GDPR. So this is not a competition. It is not a fight between those two, but, we just want to see, compare them like for like and see what is out there. And hopefully, you will learn from what we're going to be sharing with you today. You can take them away, a lot of practical takeaways, things that you can use, if you're in Nigeria or if you're aspiring, maybe to return to Nigeria, to go and do some jobs, or maybe perhaps, you're already having a discussion with, friends, family, colleagues, out there in Nigeria, about possibility of doing some business with them around this regulatory, space, then yeah, you're in the right place. There's a whole lot that you're going to take away from here today that you can make your own and that can help you maybe land that job, that contract or anything, whatsoever that you want to do with it. So again, thank you for joining. Okay, in the next so we, is our intention that 1 hour, within a space of 1 hour, we're going to be covering, everything, hopefully, everything that we need to, show you today. We're going to be covering it in the next 1 hour. All right. Just before we go into the webinar itself, I want to show you my beautiful face, or my handsome face. So that's me on the left-hand side. And I have another gentleman here called Boje, who is also a speaker. So it's going to be between us today, which is good news. I am the host, Wale Omolere. I'm the CEO of Smart Learning, also the founder as well. So I've been in this space for a while now. God is helping us, if I put it that way. So been in this space for a while. Come from heavy hands-on technical background. I found my way into management in the cybersecurity, information security space. I've done a whole lot around this so-called GDPR. I've done quite a lot around that, train people, develop curriculums and give talks here and there around GDPR. So I can say at least I have good knowledge of how this thing works, and hence what I'm doing today is just to share those knowledge with you. I also have another gentleman here, Boje, who is a certified data protection officer. He's also certified to GDPR as well. So he is a data protection specialist. So this gentleman is a bag of experience. I haven't been in this space, for a while, this regulatory space. And what I mean that he has had the opportunity to work, for so many organizations as a contractor, helping to bring their system, their processes, procedures, into compliance to GDPR. At the moment, he works for an organization as the chief privacy officer, and his experience spanned across both public and private sector. He's done some work with NHS, done some work with a digital organization. So both is working the private and also in the public sector as well. Done some projects for pharmaceutical charity organization, the university, multi-million or multi-billion global manufacturing company. So this man is the man. He's the man that you can learn a lot from. He has experience in global organization, in a word as a group data protection officer, and presently, like I said earlier on, he is the chief privacy officer for a large non-profiting organization here in the UK. Is apart from the fact that he's certified to GDPR, is also ISO 27001 lead implementer. Okay, so you can imagine it's combining both, and not only from the regulatory part of things, it's also accredited to ISO 27001. So you can imagine when you have those two combinations, do the double barrel, if I put it that way, it is good. And I'm hoping today that he will be able to share his thought, his knowledge around GDPR with you, and as it relates, okay, to the Nigerian data protection regulation. Okay. Just also to let you know, as this is our custom in any of our webinars, and we also, keep you updated, with, key events and activities, that goes on in our organization. So what we're going to be having next, which is in January, by God's grace, the 25th, you could note that date. We're going to 25th, next year, 2020, we're going to be demystifying, the Nigerian data protection implementation process. What exactly we're going to be doing here is we'll walk you through the entire framework. We have a framework that we have designed for ourselves, which we used, implementing GDPR, and we want to replicate the same, even much more better, on the 25th. You want to note that date. We're going to be bringing you information. So if you have registered today for this webinar, if you have entered your email, then what it means that if you give us the consent, then we would also reach out to you in the future, telling you about subsequent webinars. Okay, so without wasting a lot of time, I think it's best that I shut up here so that we can get into the business of the day. So Ari, you're welcome, and if you take control now and share with us your slide, and we can take it from there. Thank you.
Okay, thank you very much, Wale, for that introduction. No pressure anyway. Thank you once again, everybody for joining this webinar. Let me just share my screen. Just bear with me. Thank you for joining anyway. I know this is when I was trying to design the presentation for today.
Your slide is not up yet?
It's not up yet, okay. Hold on. So why is it not? I'm trying to share, now it's not sharing.
I have to stop sharing.
Stop sharing first, yes.
All right, cool. Sorry, apologies. We're still getting used to the Zoom factor. We just recently changed to Zoom. We used to be GoToMeeting in person before, but I think Zoom is offering us much more, features and greater flexibility. So apologies for that. So you have it now.
Okay. Yeah. I believe you can see my screen now.
Yes, I can. So just put it in a presentation mode, and yeah, we can.
Okay, sorry guys. Like I was saying, when designing this presentation, I've looked at it. What we're trying to do, we're just trying to give you a high level, because 1 hour or so would not be able to go into both regulation properly. When we do a training in GDPR, we do it over 3 days training. So I just picked out the most important part to try to compare both regulation. Both regulations looking at data protection of the data subject or the individual. And in terms of GDPR, let me just point at this point that the NDPR, which is the Nigerian data protection, is just a mirror of GDPR. But there are some areas, there are some few changes. As we go along, you'll see what we're talking about. I think in terms of the GDPR, it became effect on 25th of May 2018, while the Nigerian data protection was brought into force on the 25th of January 2019. So you can automatically see here a bit of those dates in terms of the day using that. Why the GDPR give organizations 2 years transition? That's about 2 years to prepare to prepare for the date that was on the 25th of May. The Nigerian gives you just about 6 months. In my view, that is too short a time. But I think they're on the ground. They know why they've put it that way. But however, there are a lot of organizations pushing to be compliant with that. So I'm really excited with the Nigerian data protection. What they're doing. That's the NITDA. What they're doing in Nigeria at the moment. So what we're going to be we're looking at key definitions. Are there much difference in those two? This is one area where, as I said earlier on, it's just a mirror of GDPR. So when we talk of personal identifiable information, is any information that can identify an individual. That's how it's stated in GDPR. Nigerian data protection is also the same. It's a personal identifiable information as well. So any information that can lead to the identifying of a living person in the terms I was using the article in GDPR, but Nigeria just says is any identifiable information. Another key area is consent. Both regulations place consent on the responsibility to gain consent on the data controller or the data processor. So meaning you have to give an affirmative action to consent to any processing of your personal data. Also, data subject, which is we as the individual, it's been mentioned the same way in both regulation. The controller, it's who is responsible, who makes the decision of the use of the personal data is a controller. So if an organization first to collect your data, your information, maybe you complete an online application, they becomes the controller. And if they're sending it to their third party or people that they work with, they become the processor. So you can see immediately that both regulations are the same in this key definition. So they've also talked about sensitive data as well, which is really important in terms of your data protection, how you protect data. However, it is slightly, worded differently. In GDPR, it's called special categories of personal data, while specifically in NDPR, it is called sensitive personal data. And under GDPR, they talked about anonymized data, which means that if your data is anonymized, you cannot use it to identify any living person, then it doesn't actually come under the radar of GDPR. Why in the NDPR, it's not mentioned at all. We talked about third parties, Nigeria in the GDPR. As we go along, you're going to see where we mentioned about third party, but in the NDPR, it specifically mentioned third party in the key definitions. Okay, there's nowhere it is mentioned pseudonymized data under the NDPR. In GDPR, it specifically talks about pseudonymized data and genetics data as well, and biometrics data. But we much talked about the data administrator, which is a team that is responsible for looking at data protection generally. So according to the regulation, it applies. This is where it becomes much interesting. Here, it applies to, in terms of GDPR, applies to organizations that have presence in the EU, notably entities that have establishment in the EU. But if you look at the NDPR, it talks about all transactions for the personal data, regardless of the means by which data is processed, is conducted or intended to be used in respect of a natural person. He said it's in Nigeria, but as we go along, you're going to see one area that is slightly different. Okay, so the GDPR applies to processing of personal data in the EU and outside of the EU. So if your business is outside the EU and it carry out transactions in the EU, then also EU complies. You have to be compliant with the GDPR. You have to put things in place to be compliant with the GDPR. Okay, so here where I think in my view, it might be a slight challenge. It says all in NDPR, all natural persons residing in Nigeria, and here is the key, or outside, who are citizens of Nigeria. So now, my view, where the difficulty comes in, how you're going to manage those processes. In my view, in terms of, I take GDPR, where I've involved in GDPR and try to mirror it to the Nigerian side, how would you, outside of in Nigeria, now try to monitor those citizens outside of the country? How would you know that they're processing their data, except the organizations are now having footprint in Nigeria? That is why I think, in my view, this law will be a bit difficult to implement this part of it. But however, putting that in place is also a good thing, because we are trying to protect data across Nigerian citizens' data across the board, no matter where they reside in. Okay, yeah, another the key principles where I said it's just a kind of a mirror of GDPR. The key principles here we talk about privacy. Okay, we're talking about transparency. Both regulations talk about transparency in the sense that you have to be transparent with your data subject at the point of collection, or in your privacy notices, what you're doing with the personal data that you've collected. It's just the same thing again. And then when you move to lawful basis of processing, which means the 6 lawful basis of processing are the same. So when we talk about consent, we talk about perform the processing necessary for carrying out a contract. We talk about legal obligations, and vital interest is also key as well. Vital interest is where you, I mean, it's hardly used anyway. I think most health organizations will be using that, or which means that if for example, somebody is in a hospital or in a critical situation where his life is at risk, and you don't need any consent, you don't need any lawful basis of processing to process it, that you can rely on vital interest. So if somebody is having maybe say heart attack, for example, and they needed to get more information from the GP of that individual, then the GP have to provide those information. They don't need to have any other lawful basis. Even as an employee, your other maybe your GP can call your organization to say, we want to know what kind of information you had about that person because his life is at risk. You don't need any lawful basis to process those data. You can rely on vital interest. It's also interesting that they talked about public task on both regulations. So the processing is necessary for performing a public task in the public interest. So that's one of those lawful bases you can use. Another key area that's missing from the lawful basis of processing in the GDPR, we talk about legitimate interest, which is the most thing people use, but in NDPR, there's nothing like legitimate interest there. So again, it will go down into the purpose of limitation. You have to collect the data for what you need it for. So if you need it for online sending applications out or collecting for an application, that is only what you're going to use that information for. So in both parties, you have it purpose of limitation. You have your data minimization on how you minimize those data accuracy. So your data that you give to your data to your data controller should be accurate. You can go back to help to tell them to correct any information you have. Storage limitation, which this is what we talk about, your retention period. But in NDPR, it specifically mentioned it that you must have your retention period. So you can see that both regulations comes hand in hand. So everything that most of the stuff that's on GDPR is also in NDPR. So this is why I keep saying I'm really excited when it comes to data, the NDPR. I've never been so optimistic about that. It's always a good step when you start something. Yes, it will be difficult at the start, but I know we'll get there. So when we look at both data subjects, what the right of the data subject, and in GDPR we call it the data subject's right. In NDPR they call it the individual right. So if you see here, they're both the same. We talk about the right of access, so the right to access your information. Look at the NDPR is the same, but it just worded differently. The right of access to data subject or copy of the data that any organization holds about you. Again, the right to ratification, which means you have the right to inform organization, go to organization to tell them that you want to correct the information they hold about you. In both regulations, they are the same, but they just worded differently. So in Nigeria, we're talking about the right to ratification of errors. So it's the same thing, but GDPR didn't go that specific to say the right to ratification of error, but the right of ratification is mainly you correcting errors about information organization hold about you. This is an interesting one for me as well. So the right to erasure or the right to be forgotten, and is the same thing in the Nigeria data protection. You have a right to tell organization either to erase your data or just forget about you. But with Nigerian, we put it as the right to deletion. It's the same thing. It just worded differently. Okay, so the right to restrict processing, which means you can tell organizations how you want them to use your data, how you want them to process your data. So you are restricting them to maybe process on certain data about you, and you as a data subject, as an individual in the terms of and the NDPR, you have the right to do that. The right of portability is again very interesting. So right of portability, so you can move your data between providers or between controllers. So you can tell a controller that you are moving to maybe their competitors, that you want them to transfer that same data, which is, so they have to provide it in a machine readable format, and it's the same thing in the NDPR as well. So I mean, the challenge will be on the implementation, but I'm very confident that things will work right. It will work right. Down the line, you see they've started even finding organizations now. I'll talk about that later. Again, right to object and the right to object to, you see in GDPR, I said the right in NDPR is the right to object to processing is the same thing. So you can, a right to object basically for organization not to process your data. Okay, yes, where we have some slight differences. Under the NDPR, you can see here they went far into details about the withdrawal of consent, the right to object to marketing, the right to structure data, the right to make requests to a data controller without charge. All this information are in the GDPR, but they're specifically under the data subject access right. So in GDPR, we talked about the right in relation to automation decision making and profiling. So this is where you use machine algorithm to make decisions on behalf of the individual. So you see here is specifically mentioned on the GDPR, but not on NDPR. So the right to be informed is another area as well. GDPR, you can make a request to a data controller to say, you want to know the kind of information they hold about you. Not that you want to get them to delete it, but you just want to know what information they hold about you. In my experience, not every organization can do that. It's a difficult task. You can see I've done myself. I've tried to see how these processes work, to request information from organizations to say, tell me what you hold about me. Some organizations have done it properly, but some have not. Some have struggled to provide those informations. Again, that is where the regulation comes in. I can now, as an individual, make a complaint to the ICO, which is our controller, the supervisory authority here in the UK, to say they've not provided me in this information. Okay, but specifically under NDPR is not stated there. Again, another key area is the transfer of personal data to outside of your jurisdiction, which in this case in the EU and then in Nigeria. So the GDPR also includes, okay, so here we say the transfer to third countries. Okay, so it's already embedded inside the regulation that when you transfer into third countries, you should put safeguards in place. So third countries means if you are not inside the EU and you've not got what we call the adequacy decisions, which technically mean you are inside the EU but outside. So they've given you that opportunity because you have systematic safeguard in place. You have your law is also kind of reflecting what GDPR is saying. Why in Nigeria the data protection is in the hands of NIDA itself or the HDG, which is the Honorable Attorney General of the Federation, who can authorize those transfer. So here again, it might be a bit difficult. I don't know how that is going to be implemented. Do you need to be sending requests to NIDA all the time when you want to do transfer, or later they're going to be a kind of a process in place or a safeguard in place in GDPR? So you have other technical measures like your standard contractual clauses to use to transfer data. Again, if the transfer is necessary for the performance of a contract, then you can transfer those data. So in the aspect of Nigeria, we specifically say here data subject explicitly give consent. So you can see in NDPR, you don't have to give consent, but on the other side, NDPR, you have to give consent to the process data after being informed. So the controller, the controller or the processor will need to give you that option to consent to transferring your data possibly outside of Nigeria. Why in NDPR is not stated, in GDPR is not stated that way. Again, if the transfer is necessary for the conclusion of or performance of a contract, okay, and it is of the data subject's interest between the controller, the processor, or other legal entities, then you can actually transfer without putting any other safeguards in place. Again, this is where it is the regulations, both regulations are similar. In Nigeria, it is the transfer necessary for the performance of a contract between the data subject and the controller, okay, or implementation of pre-contract measures. So you can see that it's just, we've just taken it from the GDPR, which is good. I keep saying I'm optimistic. I've been to a lot of conferences, which I speak in a lot of conferences, and when I say yes, I'm from Nigeria, and the way they excited about the Nigerian data protection, in fact, most of them are even excited more than myself. So that's what gives me the courage, the zeal to say yes, this thing is going to happen in Nigeria, because there are a lot of organizations here in the EU that is supporting Nigeria. They want Nigeria to succeed because they think that is a gateway to data protection across Africa. Also, did I just go back? Okay, so here again is the transfer is necessary for establishing or assessing of defense of a legal claim. So you would not need to put any of those safeguards in place. So it's the same thing when we talk of data protection in Nigeria. So in Nigeria, for example, we already have, when I mentioned at the top, we talked about adequacy. Nigeria already have some other countries that they've given adequacy. So if you're transferring data to places like all the countries in the EU, Angola, Argentina, Australia, Brazil, Canada, and Cape Verde, and even China, then you do need to put all those necessary technical measures in place to transfer data. Those are the countries Nigeria has considered as adequate in terms of data protection. Okay, we talked about vital interest earlier on. Is the same thing here, that the transfer is necessary in order to protect the vital interest of the data subject. Anywhere consent cannot be obtained. So if somebody is not in a position to give consent and his life is in danger, then you don't need that. This regulation wouldn't apply to that processing at that time. So it's the same thing in the NDPR. Transfer is necessary to protect the vital interests of the data subject or of other persons, where the data subject is physically or legally incapable of giving that consent. So here we talk about, again, the transfer is made from a register which, according to the EU member state law, intend to provide information to public. So if this is to provide information for the public interest, then those transfer, you don't need to put other measures in place. So this way it's very interesting in terms of Nigeria, where the personal data is transferred to a foreign country or to an international organization, the data subjects have the right to be informed. Again, this is where only part you can see that they're giving that right to be informed when we talked about the key areas of GDPR earlier on. So you can see here, both regulations are really, really similar. So again, in GDPR, they have what we call derogations. You have, this is a kind of an exemption, proper exemptions across all what we're discussing that you can use to transfer data. But however, derogations is only used on a one-off, and only use on activities that are not repetitive. So if that transfer is not repetitive, or the process is not repetitive, then you can use it at a one-off without putting any other measures in place. But in NDPR, that is not explicitly stated anywhere. Okay, here's an interesting part that talks about data breach. This is one of the areas, I mean, organizations are actually scared for here in the UK. So on that GDPR, introduction of data breach reporting is mandatory. Whereas in NDPR, it is not mandatory for you to report that security breach or loss to authority or to the data subject. Okay, the data controller is obliged to report security breach to the relevant authority, in our case here in the EU. But again, you as the DPO or the chief privacy officer, or who, if you are responsible for data protection, you have to now weigh that option yourself. You have to now, first of all, make that decision. Is it reportable to the ICO, which is the Information Commissioner Office here in the UK, the supervisory authority? Do you need to report it to them? If it's not necessary, for example, in my place of work, we have some few, which I'll call incident, where you sent the wrong information letter to a different. So a letter that is meant for me is been put in Wale's envelope. And in my organization, we've deemed that not necessary to report to the ICO because not a lot of personal information was introduced or was exposed. So it's only the name and address. So, and how many data subjects were involved is only 2 or 3. So in that case, you don't need to report to the ICO. You just need to make sure that you put measures in place to mitigate that risk that you found. Okay, so in terms of the NDPR, I said, what does it does not give the power to set, or we give the power to set up redress. So what that means is, now you go down, when we go on this presentation, we talk what we call the DPCO. Those are the NDPR have created a body that will address this data breach once it's reported. Why here in the GDPR you have 72 hours to report any data breach to the supervisory authority. So it is when you became aware of that breach. You say, for example, it happened on a Friday when you finished from your office. So it doesn't mean because it happened on that Friday that the 72 hours start counting. Then it only happens when you have identified it. You've known that's a data breach. So if it's on Monday or Tuesday, you knew of the data breach, that is when your 72 hours start counting. So you need to have records of those incidents when it happened. And you don't need to provide all the information to the ICO supervisory authority at the same time. You can provide them in bits, but just letting them know what has happened and what you're what you're trying to do to mitigate that. While in the NDPR, it states that this body or administrative redress should be done within 28 days of that when you report that breach, when you try to conclude that investigation. Okay, this is what I just explained earlier. It's not necessary for you to report it when you think it wouldn't affect the right and freedom of the data subject. Okay, in NDPR, we have our supervisor. The supervisory authority is the NITDA, National, I think, Information Technology Department that's responsible for that. So it invites parties to respond to allegations made against them. So if you make an allegations against, for example, I make allegations against an organization, it is the onus is now on that organization to make to report that to the supervisory authority or liaise with the supervisory authorities. This is where our sanctions, it's a bit we'll see how it's different there. So in the GDPR, you have 2 tiers of administrative fine that can be levied on non-compliance of GDPR. NDPR, the breaches to a data subject privacy right shall be liable in addition to any other criminal liabilities. So you see the NDPR kind of slightly broaden that fine. Okay, so here are the fine. Under the GDPR is clearly stated what you need to do. Whether you are a small organization, medium-sized organization, whatever, it is absolutely stated that the fine is either 10%, 10 million, or 2% of your global turnover, whichever is greater. And the more serious offense is up to 20 million, or 4% of the global turnover. But in terms of Nigeria data protection, you see they've kind of broken it down into pits. He said in the case of data controller dealing with, you can see here, if it's more than 10,000, you're having 10,000 data subjects. Okay, the fine would be 2% or 10 million of the global turnover, whichever is greater. But you can see here where it's different. The specifically NDPR specifically stating the threshold of that fine, how you can get that fine, and then it went back to the second tier again, which is if you have less than 10,000 data subjects. So your fine will be 1% or 2 million of your revenue or your global turnover. You can see the difference here. So I think, in my view, why Nigeria is stating that they possibly might be making it lead to organizations, so they just want to hit every organization with the same with the same fine across board. But however, you see that in GDPR, the fine are not specifically 10 million or 20 million. It is also proportionate from the supervisory authority. Okay, so it's discretionary. So if you or the ICO came to investigate you and found out that you have processes in place, you have good measures in place, or the same, they were still breached. So it's going to be, they're going to take those into consideration. So they're not just going to hit you with 20 million or 10 million fine just because there's a breach, just because you've made some aspect of it. They will take things into consideration before they issue fine. Hence, those of us in the UK, you see that the ICO have find a lot of organizations. So if you go to their website, they find a lot of organizations, but not up to that 10 million. They look at proportionate to say they'll give you a fine. It could range from 100,000, 200,000, or 500,000 as a fine. So, but the good thing is that you have this fine, and also in the Nigerian data protection, prior to that, there've been investigation. That's why I said I'm optimistic that things will work in Nigeria. Now the national, that's the NITDA, I think announced on the 4th of October 2019, in accordance with the section, I think is section 6 of the NITDA Act, which was also to show that we've done this before, which was also enacted in 2007. Okay, they already started investigation against a company called TrueSoft Services. TrueSoft Services or Truecaller is an Indian organization. So they've announced that they've started proceedings against them because they breached the privacy policy and terms of services that's relating to data breach in the GDPR, in the NDPR. So you can see that, yes, we're taking kind of a baby step forward, it's only just going to get better. But by the time you know that you're finding organization and organization are complying to it, it's just going to get better. And also, just to throw this in terms of jobs, during the course of my research, I found out somewhere that if we get this data protection right, every organization abide to these, people that followed this, and also the authority flex their muscle to find those that are breaching the regulation. They think it will create up to 300,000 jobs in Nigeria. From, I think it's going to be from the very high to your data protection officer down to somebody responding to your data subject access request. So that is a step forward. Imagine if that works. So creating 300,000 jobs in the area of data protection on Nigeria. It's just going to be a starting point for us to start moving forward in other areas of the government or country, so to speak. Okay, the appointment of a DPO is certainly there. In GDPR, the appointment of a DPO is mandatory, but however, there are conditions that you can have that you need to put in for you to appoint a data protection officer. For example, if you're a public authority, you have to appoint a DPO. If you are a charity, it's obvious that you have to appoint a virtual. So if your core activity is engaged in lab processing of activity, so if you are a 5-man, 20-man organization and you process high volume of personal data, okay, then you have to appoint a DPO. So we'll know why this asks you to appoint a DPO when we go to the rules of the DPO later. Okay. If the core activity consists of large-scale processing of special categories, when we talk about special categories is defined here in GDPR as well, to do with your religion, has to do with your sexual orientation, has to do with your membership to organization like that. Those are special categories of data. Then you have to appoint a DPO. Okay, it applies to both controller and processor. While in terms of the GDPR, NDPR just made it blank. Every organization should appoint a DPO. Oh, that means a data protection officer. You see, I think where the NDPR is going, that as a data protection officer, if you have a data protection officer in your organization, you should be able to advise the organization, monitor the compliance to the regulation. So you see that Nigeria made it blank. You have to appoint a DPO. Again, that creates jobs again for organization. But the challenge is how do you get those people that are qualified that you can appoint as a DPO? So that's where the bit of the challenge is going to come from. Again, in GDPR, even if you are not inside that criteria of appointing a DPO, it's always a good practice to appoint a DPO where you can or where you can afford it, because it will help your organization to be compliant with GDPR. And if ever there was a breach in your smaller organization, the ICO will take that into consideration as well, that you've got a DPO that will advising you on the requirements of complying with GDPR. Okay, here are the tax of the DPO in terms of in GDPR. The responsibility of the DPO is to monitor compliance, is to raise awareness. You have to train constantly, monitor the compliance of organizations. So I've done a lot of DPO roles, and what you do is basically just constantly looking at what the organization have in place, looking at their record of processing, looking at how people process data, making yourself visible to tell people to come to you. So people will always come with different type of questions. So ask you questions: is this processing that I'm doing, is it right? So again, the key area in the GDPR is a DPO cannot be dismissed or sacked based on the advice he or she has given to the organization. So I think it's a way for you to cover, trying to cover the role of a DPO, because imagine if that's not there, everybody can just appoint a DPO, sack a DPO anytime they want, based off if they don't like the advice that you're giving to them. I mean, I've got experience of that without mentioning the organization as well. So you tend to sign some NDA, that is non-disclosure agreement. in place. So those are the role of a DPO. You monitor because you're constantly looking at what they have, constantly evolving, constantly advising the board. You will, in some organizations, you will constantly go to the board every month to provide a state of your data protection, to give them what you found, your data, how many subject access requests you've received, how you've handled it, what are the challenges you have in, how you need to improve the organization so that we're getting close to compliance. So all those are things you do are the tasks of a DPO, okay? While on an NDPR, you just need to ensure that the data controller and the processor adhere to the regulation. Is similar, but worded differently to cooperate with the supervisory authority, which is NDPR. You see down line when we go down in this presentation, we're going to talk about some other thing that's close to this. So you're working with the data protection organization, ensuring that controllers have things in place, ensuring that controllers have policies and procedures in place, privacy notices, and that is the same thing as GDPR. So the tasks of the DPO on both regulations are slightly similar. Okay, when we come to certification body, under GDPR, we have what we call Article 42 and 43 talked about certification body. However, they have not been the senior authority that is in task to do that certification at the moment. Okay, currently there are no ICO approved GDPR certification scheme in operations, but I know as time goes on, they will develop those areas, especially now the ISO 27701 has just come out. Most organizations, it's an extension of ISO 27001. Most organizations will try to rely on that. That is what most third parties, if you're doing you're employing a third party, this is what they might be asking, how to show you that you are compliant with GDPR. Again, I mentioned about how the NITA is going to implement some of the regulations under the regulations. So we talked about here is what we call the Data Protection Compliance Organization. These are entities that will duly licensed by NITA to train, audit organization, consult with organization to advise them basically on data protection. Why? You see here, Nigeria specifically took that, and you need to actually apply to NITA to be granted that license. Currently, as at 18th of October, there were only 27 organizations that have got those certifications. So that tells you the NITA is doing something good. It's trying to get organizations. So again, when I talked about optimism in getting this right, we have other one of those big 6 consultancy firms in the UK or across the world. In Nigeria, you have NRY, yeah, you have other big consulting companies, KPMG. They're all in Nigeria now working on data protection as well. So you see that I would say the Nigerian data protection is going places. People are taking it serious. Organizations in Nigeria are taking it serious, and other bodies are taking it serious as well. And the NITA has also, they're also collaborating with an organization called the European Data Protection Office. It's a kind of out separate from the regulation or the supervisory body, but they act as representative if you are not in the EU. So they act as a brand. Nigeria is collaborating with that organization, and once that collaboration is going where you will see that in order for that organization to put their name to be associated with a country or a regulation, they must have seen something good in it. So they will be providing advice also to Nigerian businesses that are trying to do business in the EU in order to be compliant with GDPR because we are a third country. Okay, it also stipulates that data controllers would need to present a DPCO, which is the Data Protection Compliance Organization, auditing verification statement, okay, to NITA to show that, yes, these organizations have audited your organization to make sure that you are compliant with the regulation. So, okay, and again, something that's slightly different. The NDPCO will also be mandated to do auditing. So organization will need to self-audit, will need to provide every 6 to 12 months with first about information, what they've done, what the NDPCO have done in the organization to be compliant with the GDPR. So what it is that every 6 to 12 months, you have to provide that report to NITDA. And the deadline is always, I think, around June, maybe 25th of June, 25th of July. Every year, you have to provide that. And in this year that is ending, it was on the 25th of July that they were supposed to provide those information. Okay, thank you, guys. I think this was just a brief brief overview of both regulations. However, we conduct training on GDPR, and then we're looking to conduct training, in-depth training on NDPR, because there are other areas that's not mentioned here, like in Nigeria, NDPR, they talked about whistleblowing specifically, they talked about CCTV specifically, there are other areas that need to be addressed in terms of training, because 1 hour will, even if we want to just take data subject access request alone, it will 1 hour will not be enough to actually trash that out. So this is just a brief stop. It's an introduction to tell you that yes, there's these 2 regulations that are coming up, not only in Nigeria, but every area. The GDPR has done, have brought data protection to light. Every area you go now, you see data protect. Every country try to bring in their own data protection regulation. Most of them is just a mirror of GDPR. We have the Ghana. We have in Africa. We have a lot of them in Africa, but all people are really, really excited about Nigeria, because they're seeing that if Nigeria pushes it well and if it's done properly, it will be a yardstick for other countries to follow in Africa. And so that is why I'm so excited about this regulation. Yes, it's going to be a baby step, but we'll finally go there. So thank you all for listening, and I will open the floor for questioning if you have questions, and Wale will be coming on to do some other stuff as well. Oh. Hi, Wale.
Hi, Ari. Thank you. That was super duper. I know there's a lot that you wanted to share with us, but because of the time constraint, we can't do an in-depth analysis. And if we try to do that, it would just mean that we have turned the webinar to training. And that's not what we want to do. Today. Thank you so much. So what we're gonna do, though I still have a few things to share with people on the call today, because if you look at our agenda, there's an aspect of the agenda that talks about the impact of NDPR, Nigerian data protection regulation. So in the next few minutes, I will try before we go to the questions. So bear with us. I know that we're supposed to finish 12:30. Just 1 hour, but you can see that there's a whole lot to share with you. So we're going to be taking taking another half an hour or 20 minutes again, if you don't mind. And I hope that you stay with us to the end to walk you through the impact of the Nigerian data protection regulation. So Ari, if you stop sharing, and if you
I've done that now.
If you give me the control.
Okay, I think you're off now.
Yeah. Okay, so we're still going to come back to the question and answer in the next few minutes. So please bear with us. Like again, in the next few minutes, I will try as much as possible to walk you through a couple of slides, and hopefully, you can learn something from here. So in this section, what I intend to do is, pretty much straightforward. Is just one step further from what Harry has discussed. A very high level, what Harry has discussed with us. I will now break it down slightly, a little bit. Break it down slightly, a little bit, so that you can maybe put some context around this, so that you can understand it better. I mean, for some of you that are already GDPR expert, you can relate to some of the things that I'm going to be talking about in the next few minutes. All right. So the topic for consideration here, we're going to be looking at, customer consent. All right. So I call it data subject. All right. But I'm going to be using a different word now. Taking it into, more practical now. I'm going to be using the word customer consent, right to data erasure or right to freedom, supplier management, data security, and the future opportunities that are out there. All right. Ari mentioned a few of those opportunities when he was talking about, the fact that, Nigerians, in Nigeria now, organizations are now compelled, all right, to appoint DPOs. And if you think about that in terms of numbers, how many people can get job? So literally, if this goes well, you can get people off the streets and they can be gainfully employed. All right. So whilst the NDPR, which is the Nigerian Data Protection, apply across all businesses, organization, processing personal identifiable information or data in Nigeria. But for the purpose of our discussion today, this afternoon, next couple of minutes, I am going to make in reference to financial authority, which is the bank in Nigeria. All right. So Ari has been using the word organization. All right. But let's not bring it down, further down. I'm going to be making my reference to banks in Nigeria. And all throughout this webinar, in the next couple of minutes, also, I would like you to know that in the course of this webinar, I would be using certain words interchangeably. So when you hear me use the word firm, when I use the word businesses, financial institution, a bank, it means basically the same thing so that you don't get confused. They all represent data controller in Nigerian data protection regulation. Under that remit, they would mean the same thing. And just as Aria said, this came into force on the 25th of January. And it is a day, 2019, that is a day of reckoning, for most organizations in Nigeria. So this was the compliance deadline for Nigerian data protection regulation, which applies to any businesses conducting or any company conducting businesses in Nigeria or with Nigerian companies. Ari also mentioned that as well. So it would include, businesses across Africa, Ghana, anywhere, that, Nigerian data or Nigerian data citizens are being processed, so they are compelled by this law, just as GDPR compel every other organization to comply to GDPR, especially if they are processing, EU data. Okay, so with this change, there's going to be a whole lot of impact on companies. All right, it would impact different businesses. It would impact financial institutions. It would impact education. It would, think about it. All the industrial verticals within Nigeria, this would impact them. So what does the introduction? So the question we want to ask here is, what does the introduction of the Nigerian data protection regulation, what does it actually mean, all right, for financial institutions? And which area, should they be focusing on? Again, what you have before me, these are the areas that I'm going to be talking about in the next few minutes. I'm going to be talking about customer consent, right to erasure, supplier, management, data security, and the future opportunity. There's so many other areas, that they should be complying with or they should be looking at. But just for the sake of time, we're going to be looking at these few ones. Okay. So customer consent, all right? So under the Nigerian data protection, which is very similar to the EU GDPR, all right? These specific areas, okay, are the areas that, it would greatly impact how business is being done in Nigeria. So under the terms of, GDPR and Nigerian data protection, personal data refers to anything, just as Aria said, anything that could be used to identify, an individual, such as name, emails, IP addresses, social media profile, social, in Nigeria, we don't have social security number, but whatever that you use to identify a natural person, it would, greatly be in scope. So the Nigerian data protection regulation explicitly mandate, organization to gain consent, from their customers, it mandates, financial institutions to gain consent from their customers about the personal data that is gathered. All right. So individual, which is banks again, should know what information organization or banks are holding for them. And in the context, in the consent system, banks again must clearly outline the purpose for which the data was collected, seeking additional consent if the organization wants to share information with a third party. And a third party here, could be any other organization working for the bank. So for example, if we take Eco Bank as an example of a bank in Nigeria or in Africa, and if they have likes of another company like e-Transat, which is a kind of payment gateway that is working with them. So e-Transat would be, a third party to them, all right? A third party to them. So if data is involved where they are being sent, to another third party, then GDPR and the Nigerian Data Protection Regulation mandates that a customer, you should seek the consent, from the customer. So the question is, so what are the bank's obligation under customer consent? And this is what is right before us today. It must again be freely given. All right, bank must ensure that consent is freely given, which simply means that, the consent essentially means, freely given consent essentially means that you have not cornered the data subject, you have not cornered the customer into agreeing to you using their data. All right, consent should not be regarded as freely given if the data subject, the customer to the bank, has no genuine or free choice or is unable to refuse or withdraw consent without any negative impact. So the bank will work very, very hard to ensure that, whilst they are collecting data, from their customer, and they intend to use those data in the future, they must get the consent of, the customer. The second one, that it must be specific, all right? The request for consent should be presented in a manner which is clearly distinguishable from other matters. It should be cleared what data processing activity the bank intend to carry out, granting the subject an opportunity to consent to each activity. So when the bank collects data, all right, from the data subject or their customer, it must be specific what those data are for. If it's for marketing purposes, that should be stated in the consent form, and the customer should be able, if they like, agree to whether the bank should use their data or not, okay? So the third one is it must be informed. So what this means that, the data subject or the customer must know your identity, what data processing activity you intend to conduct, the purpose of the data processing, and they, also would have the right to withdraw their consent at any time. So, okay, the processing mechanism must be in such a way, or the consent form must be in such a way that the customer should be able to take their consent at any time. So anytime they feel that, they don't want to be part of your organization, or they don't want your data, or for you to process their data further, there must be a mechanism in place that allows them to withdraw their consent. Then we also have that, it must be unambiguous, okay? There should not be any question about whether the data subject has the consent, all right? It must be clear again to the data subject what you intend to do with their data. And lastly, the data subject should be able to revoke, all right, their consent, which means that, wherever or any time that they feel unhappy or how their data is being handled, all right, they should be able to withdraw that from the bank. So you would agree with me, with this in place, you can see that this regulation is quite stringent in the sense that, it gives the power, back, to the customer, which in other words, the data subject. The bank would have to work very, very hard. We're talking about customer data here, to put together a mechanism, to make this possible, where, data, where customer, will be informed about the data that they hold for them, and where customer can also exercise, where the customer can also exercise their right as well. So this would greatly impact how banks in Nigeria or financial institutions in Nigeria, would operate going forward. Next on the slide is the right to data erasure or right to freedom. Ari also covered this bit as well. The right to erasure, also known as right to freedom, is new. It's new. It's not new to us here in the UK under the GDPR, but it is new in Nigeria. As a matter of fact, the underlying principle of this right is that when there is no compelling reason for customer data to be processed, then the customer, the data subject, can request for their data to be removed, to be erased from the system. The system could be a database. This requirement under NDPR, all right, empowers every Nigerian citizen with the right to data privacy. And under this requirement or this term, individual can request access to or be removed off their own personal data from the bank without the need for any outside authorization. So they do not need to be authorized by anyone. Once the request comes in, to the bank to say, take my data off your database, they should be able to do that immediately. So financial institutions in Nigeria may keep some data to ensure compliance with other regulation. Maybe, for example, the AML. I understand they do AML in Nigeria, which is the anti-money laundering. They, under other statutory or bodies or regulation, they might be able to keep data. But that does not negate, the Nigerian data protection, especially under the right to data erasure. But in all circumstances where there is no valid justification, the individual's right to be forgotten must be applied at all time. All right. So now that we have defined what it means, or what data erasure means, or right to be forgotten, in the next couple of minutes, I'm also going to be looking at, how do we attempt to answer the questions that we have here. When is the right to erasure applicable? Why is erasure important? How does it affect organization? See, the right to erasure isn't always applicable with companies, whether is the educational sector or in the financial services, only needing to, those ones that is only needed to comply to certain instances. Individuals have right to have their data erased or stopped. Companies to processing their data, where the NDPR right to erasure, right to forgotten requirement comes into force. So when the original purpose for a personal data is no longer necessary, then the data itself is no longer necessary for the purpose. When individual no longer consent, then right to data erasure or right to be forgotten can also be enforced. Then the other question is, why is the right to erasure also important? That we mentioned here to customers. This greatly increase the control that they have over the distribution of their personal data. So you would agree with me that most organizations, especially in Nigeria and across the world, they would have suppliers. They would have companies that does bit and piece for them, to make them stay in business. And occasionally, they would also share data, customer data, with this organization. So with the right to erasure, it also helps the data subject and the customer, to keep abreast of the data that an organization holds for them, also in the terms of the distribution as well. So for organizations, there are so many implications when it comes to data erasure. So this change that we're talking about, it would increase the need for ability to be able to prove, the relevancy and the need of all data that an organization hold, for the data subject. They would also have the need to identify and gather all data relating to any one data subject if they do exercise, the data right or the data right to erasure. And these are some of the questions or challenges that most organizations will face, in Nigeria, especially if they want to comply to the NDPR. And next, we're going to be looking at supplier management. So for most of you, you're familiar, with supplier management. In other words, some people will call it a third-party management. Others will call it, vendor management. So whether you call it third-party, whether you call it supplier, whether you call it vendor, it means the same thing. And under this particular topic, we're going to be looking at outsourced IT system, data flow across multiple IT applications, and also involving the procurement team. So you would agree with me that IT system form the backbone of every financial institution, not even financial institution alone, other industrial verticals as well. So with client data, customer data continually passing through multiple IT application. Well, since the NDPR is associated with client personal data, it means that organization, financial institution, we need to understand how data is flowing across various systems. All right. So, for example, if you want to execute a transaction with EcoBank and you want to transfer money to other African countries, so it would mean that EcoBank would have to liaise with likes of eTransact, which is a kind of payment gateway that would help them, to transfer the money from one location to another. So you can see there that your data would have flowed across two multiple IT system. And what this simply means that this would increase the trend towards outsourcing development, and support functions means that personal customer data is often accessed by external vendor. It is true, because if eTransact, for example, or EcoBank is working with eTransact and they are doing business together, your data would have to flow, or the customer data would have to flow from the bank to the payment gateway. Okay, so here the question we also ask is the overall data protection, whose responsibility it is. Now that we have established that, listen, there are multiple IT systems that are out there, banks would have to work with various suppliers, vendors, to fulfill customer obligations sometimes where you have to transfer data. Then the question is, whose responsibility is the overall data protection? In my opinion, and looking at this from best practice, the ultimate data security responsibility usually lies on the shoulder of the data controller. So in the case of the scenario that we gave earlier on, EcoBank and eTransact, so the responsibility for the data protection will sit with EcoBank, okay? Because in the first place, the customer did not give their data to eTransact. They've given their data to EcoBank, and EcoBank has the responsibility to make sure that whatever the customer want to fulfill in terms of business transaction, that time is being done, but data is involved here. So the customer will not go and hold the payment gateway company responsible, but rather it would hold the bank responsible for their data. So again, to sum it up, that responsibility would have to be shouldered by the data controller. In this case, now we're talking about the bank or the financial institution. Again, the question again we ask is, but how do you start? So if this responsibility with this multiple IT system that we talked about, is true, how would the bank, how would the financial institution, the data controller, how would they start to effect this supply management, this obligation that is that they have to fulfill the requirement of the Nigerian data protection regulation? Again, in my opinion, I'm still coming back to this. I think that you cannot effectively provide protection for the data where you do not know the whereabouts of the data. You would agree with me that you can't do that. All right. So if you do not know the whereabouts of the data, you cannot effectively protect those data. or if you do not know the supplier or the vendor who is processing or handling those data on behalf of your organization. So, Echo Bank cannot do that until they have a good visibility of who, their supplier or their vendors are. So, in my opinion, and from best practices, this is what I think, financial institution in Nigeria should do. So they should start by identifying their suppliers or vendors. All right, the procurement team have got their house. I've got the house of suppliers. They have to put that in order by intimating the knowledge of the supplier. So the procurement team, in most organizations where things are done, properly, they would have good visibility of the suppliers, suppliers or vendors that are, providing services for that organization. They would have good visibility of it. They will know who is doing what per time, where things are done properly, Okay, so I use that word. So starting, if you want to get this right, then you have to identify who your suppliers are. The procurement team, they will conduct a due diligence exercise to gain a better understanding of their primary supplier. They would have to identify who the sub-suppliers are. They would have to identify the third level supplier, and so on and so forth. Here in the UK, what we do is under supplier management, there's something we call tiering, supplier tiering system. So you can, put together a tiering mechanism whereby you would have your suppliers, put them into different category. You could have tier 1, tier 2, and tier 3. Whatever you call it, in your organization or where you work. So with that tiering mechanism, it would help you to categorize your supplier. You will know who is handling data, per time. You will know who is not handling data and per time. And I think that, this is the starting point, for any organization, particularly banks, to help, to help hold their supplier accountable and to help them, to comply to the Nigerian data protection regulation. It does not actually stop there, because listen, by the time you have a good visibility of who your suppliers are, then you can now start to ask the right questions. What data do they hold for us? What data do they process for us on our behalf? What are the categories of data? How sensitive are those data? Then, you can start to bring them into compliance to the Nigerian data protection regulation. Let's move on quickly. Next, we're going to be talking about the data security. So the data security is all encompassing, okay? It covers so many areas, all right? And as a matter of fact, here you have to be looking at handling how financial institutions, they handle large quantity of personal information. That is true. So if you think about Barclays of this world or the HSBC in UK and across the world, and you also think about other financial institutions, again, example like Echo Bank, First Bank in Nigeria, they would have enormous amount of data that they hold for their customer. They would also have special categories of data as well. So within the financial sector, specifically, NDPR represent a significant change. So since most financial institutions, they are tasked with handling large quantity of personal information, financial institutions have the need to step up with manpower and also invest in new IT product. So these are also the opportunities that lies in there. You would agree with me for those of you that you have done GDPR here in the UK. You will notice that since we had the GDPR, a lot of organizations spring up like we had so many. We had different types of applications, like likes of One Trust, and I mean, they're quite, they're uncountable, the number of companies that spring up on the back of, the GDPR. And I see the same, happening in Nigeria as well. It's just that I'm afraid that, the same company here, that have those applications, they will take it, to Nigeria and make us of the money, so we have to wake up to reality, ladies and gentlemen, and these are the opportunities that lies ahead. I hope that this will go ahead and it would change the ecosystem, data security ecosystem in Nigeria, because there will be need, for, new IT technology, new product, that can be used, that can help various businesses in Nigeria, to bring them into compliance to this new regulation. So the personal data, hold, by banks would tend to be most interesting hand of the spectrum. And do you know why? It's because it is often linked in an intermediate way to store of financial value. And so it is regarded as being high value to hackers, okay? So this personal identifiable information we're talking about here, is very, very important. You would know, because if you reside in the UK, you will know how valuable, or how we tend to, protect anything that falls within the scope of personal identifiable information. And the same is also true, because they are so valuable, the people from the other side, the bad people, they also want to access them, to be able to steal those information. So the most common store of value in the modern day time has been money, currency, commodity, like precious metals as well, and they are of great financial gain. But this assertion is gradually changing as data holds more financial value. These days, there's a saying that data is the new oil. All right, and it is a new oil for those who understand the true worth of data, and that can gain some intelligent insight into those data through data analytic. So you would agree with me that, you see, Facebook will not be Facebook today if you have not given your data to them. That's the truth. So imagine we all take our data away from them. They will stop being Facebook. It's because you consent, you have given your data to them. That's why it's Facebook. The other day, we were in the meeting and somebody was showing us an analytic of the amount of data that is generated on Twitter in a split of seconds. Ladies and gentlemen, it would blow your mind. So, right, I'm speaking to you now. Hundreds and billions of people are tweeting. And if you do an analytic of it, you could see how, data is coming from all over the world, So you see, data is the new oil. And so the point that we're trying to make here is financial institutions, you and I, everyone, that we can take advantage, through data analytic, the intelligence, the insight that data communicates. And if you can do that, then, you can also make a lot of money from it. So the point that we're making here, whilst, the security of data is very, very important, but we could also look at the value, that it possesses. So financial institutions tend to hold so-called special categories of data as well. In fact, sensitive information, such as, as Ari has mentioned, earlier on, so if you go to bank and you want to take loan, they will collect all sort of information from you, and those information can be deemed to be sensitive. So given the greater protection that this type of data is afforded, holding and using this data comes with data compliance challenge. That is the truth, okay? So banks would have to do something extra. So with this in mind, it would be fair to say that Nigerian bank doesn't have the easiest task, at hand. On the other hand, they need to comply, maybe with other regulations, like I mentioned earlier on, AML, know your customer guideline, required, and that will require them, to collect, a large amount of data in a bid to safeguard against money laundering. On the other hand, the Nigerian Data Protection Regulation, the NDPR, mandates bank to give their customer more access to this data. So bank now have a kind of enormous obligation in their hand to protect customer data, but also to comply with a number of other provisions that are designed to protect people generally. So you would agree with me that this is a very top position they find themselves. And on top of this, the data isn't always simple to access. Do you know why? Because large banking groups, they have probably, like in Nigeria and everywhere in the world, they have grown as a result of merger and acquisition. All right, so they bought smaller company. They've grown over time, and they have amassed data over a longer period, and this is held in various legacy IT system. Guess what? This legacy IT system are usually operating in silo. So, most of them, they're not even talking to each other, and they have customer record all over in this, in this legacy IT system, which again, it could be, a database. So they have it all over. So this is an enormous challenge for them to particularly protect customer data and also to comply to the NDPR. So I don't want you to look at the challenge too much, but I want you to see the opportunity within. See if this is going to go as far, and I pray that it does, it's going to go as far as we anticipate. Then there's a lot of opportunity for us here. There's a lot of opportunity for banks, and there's also a lot of opportunity for the individual as well. All right. So this presents a particular challenge, in respect of requirements to also delete data when it is no longer necessary for the purpose and that is intended for. Because listen, if you have systems that are operating in silo and the regulation says, remove all the data, customer record, then it means that, you can only remove you from the system that especially if they are if those systems are not, joined together, if they are not communicating. Okay, that would be a big problem. And lastly, the opportunity that we're going to be talking about here, and this is where we're going to stop for today, so that we don't take you over the time that, we've gone over the time, and we do apologize for that. And this is where we're going to be stopping today. Future opportunities. All right. And number one, I want you to know, that the NDPR, it is not, it is an evolution, not a revolution. So if you think about that, for every evolution, there's always opportunity to do something. All right. There would be various IT system innovation, as we have seen in GDPR here. All right. Maybe you already thinking you might want to take, one trust to Nigeria. You might perhaps be thinking, oh my goodness, what are the opportunities that lies there? What do I need to do? How can I, build that application? So if you're thinking in that line, start to, work for your dreams and, those visions that you have, and see what you can do to better, the state of things in Nigeria. Then competitiveness. So it would mean that, banks, will not have to compete, as we have seen in the last couple of years, in the UK, on the back of the GDPR and other regulation that has come forth. We've seen so many banks that have so many new startups. We see Revolt, the new bank. We see Starling. We see TIDA. We see, give me those names. So many banks that are just new generation banks. And if you're not careful, the older generation banks like Barclays and HSBC, they will soon go down if they're not careful, because these banks they're doing things, in a different way. They're engaging the customer using, various IT, technology. The app is so seamless, compared to what we have with the older banks or financial institution. Then fourthly, then we have the big data job growth. Again, if this goes well, I'm talking about the Nigerian data protection regulation, there would be need, for big data, right? So companies will now start to have a need to get insight into the data that they have for their customers, so that they can create more services. Again, that would, kind of fuel the innovation that we are talking about. And lastly, there we will have the rise of data protection officer. There will be need for organization to employ people to help bring their business into compliance. So these are all the future opportunities, that would be driven by the Nigerian data protection regulation. I hope you can see these opportunities as I see them. So don't think, and this is to encourage you, don't think as though you're that person that is just going to go and do some piece of work, for them and earn money. Think as though, as that individual, that can create something, that can birth a new innovation, well, if you're Nigerian, which I assume you are, that can birth a new innovation, something that you can take back to the motherland and help them to support their system, and help, to even employ other people. So the opportunity is endless, ladies and gentlemen. And we're going to stop here. Also on our agenda, we have the practical step to initiate the Nigerian Data Protection Compliance Project. And we have it under these few headings: building consensus, assessing risk, and creating awareness, develop remediation plan, and implement change. For the sake of our time today, I would not be talking about this because we've gone well over time. But like I mentioned earlier, on the 25th of January 2020, we're going to have another webinar where we will continue, to talk about this framework that Smart Learning has created, that can help anybody whatsoever, to bring the organization into compliance to either GDPR or the Nigerian data protection regulation. Okay, so this is where we're going to stop here. Stop, ladies and gentlemen. I just want to thank you so much for your time. I do apologize that we've gone, well over it, over 30 minutes, but I believe that you have enjoyed, the webinar today and you've learned something new. So what we're going to do in the next few minutes is I'm going to open the floor, and, we would take questions from you. If there's any questions that you want to, anything that you want to say, well, as long as it's in line, what we have discussed today, I'm happy to hear you out. And also I will try as much as I've got Harry here, and I've also got Adol on the call as well. So where I'm struggling, I can just call on this individual to help me out, to bail me out, basically. Okay, so I would open the floor, please. Let's make it, easy for ourselves, so that if you have a noisy background, please do not speak so that we don't mess up the recording. The plan is you have registered for this webinar today. We plan to share the recording with you as well, and so that you can listen to it at your convenient time. And just whilst I have you here, for us, Smart Learning, we are partnering with a company in Nigeria, and I hope Shegun will give Shegun the opportunity to say something to help the businesses in Nigeria, to bringing them into compliance to the NDPR. All right, so we're doing a whole lot in Nigeria as we speak. Okay, and we're so excited about it, just like Ari has said. And again, if you want to talk to us about anything, feel free to ring us or to email us, and we're hoping to discussing with you as well. So I am going to open the floor, and it's going to be very quick.
Hi, Wale.
Yeah.
Yeah, okay. As you're doing that, well done for that presentation. There's a question on the chat, which I should just answer while you are doing that. Okay. I think he asked that, he said, we know Nigerian host.
Are you going?
Nigerian host applications on Azure.
Ari, to repeat your question, I unmute, then I think somebody has a terrible noisy background. And okay. I'm really afraid of that. So yeah, if you repeat that question, then I think the question
here says, we know Nigerian host apps on Azure, AWS. Do you think they are breaking the law by hosting people's data outside Nigeria? What do you mean by, okay, two questions. What do you mean by anonymization? So I'll take the first question.
All right.
The simple answer would be no. They are not breaking any law. In the same, I'll make it twofold. One, because Azure might have their instance, that data storage instance in Nigeria or in Africa, for example. So in that sense, they're not breaking it. But however, since this law have come in now, it is now the responsibility of organizations now to speak with their provider, their third party, to see how they're going to host those data. I don't know if you're bringing in a point in the point of Nigeria data protection of GDPR, but if it's GDPR, I don't think they're breaking any law. It's now the responsibility of that third party to make sure they have security measures in place when they are transferring data between those third countries.
Yeah.
Go
on, Ari. Go on.
And the second one, you said what you mean by anonymization. Anonymization is the process, for example, of removing personal identifier, both direct or indirect, that may lead to an individual being identified. So what that means, that is why when you say part of anonymization is not GDPR don't see that as you breaking the law when it comes to that.
Okay.
So when it comes to that, so that's the difference. That's what anonymization is. All
right. Thank you, Ari. Just to add to what Harry says, thank you for that question. I think it was asked by Obi. All right. Ari was absolutely spot on. So they might not be breaking any law, but if you're, say for example, if you're hired by EcoBank now or First Bank as a DPO to come and help them bring their system or to compliance, and I would expect that the scope of the compliance is data, and anywhere that data flows, you have to focus your attention to it. It's not as I'm glad that Ari said that, but it's not as simple as that. In the real world, so you have to understand the mechanism on how data is flowing in and out of that organization. So if you're GDPR, which I don't know, if you're GDPR, if you've done GDPR in the UK here and you have worked for an organization, you know what we're talking about here. So there must be part of your auditing is you're asking the right question. How is data being processed? Where is data coming from? How are we receiving data? And this is what you also get from us. If you want to learn more about the NDPR, you want to do training further to learn, So in the training, we would demystify all of this. We'd explain to you the sort of questions that you need to be asking. All right. So say, for example, you are working for First Bank or EcoBank now, so you have to understand all of those dynamics, how data is flowing in and out of that organization, where it is going. So you would have, with that data flow, there would be a kind of a good holistic view, all right, of where things are. And if you identify that data is going into the cloud, then that's another conversation entirely. All right. And then the question is, if it's going into the cloud, is it Azure? Is it Google? GCP? Is it is it AWS? Whatever it is, it might not just be even among these big players that we talk about. It might just be another, another cloud service provider. So if you understand where it is, those data are resident, then you can start to ask the question again, to the supplier. In this case now, the cloud provider, where you can start by asking, do you comply to GDPR? If they said yes, which I believe most organizations now, especially in the UK, are now complied to GDPR, then do you know what will now happen? You can now, what Ari has taught you, you can go back, all right, see this mapping that Ari has done in a very high level, to see the likes for like, because you don't need to reinvent the wheel, isn't it? So if GDPR is NDPR, then NDPR is GDPR, all right? So you can just look at it, okay, if you're complying to GDPR, so it means that you're also fulfilling the obligation on that NDPR. Then you look at the gaps, where the gaps are, and you begin to ask that right question. Show us or demonstrate to us that you're complying to GDPR. So they will come and say, they will show you a sort of form of audits they've done out. Ari was talking about a standard earlier on. They can say, oh yeah, this standard, we're working on it, which is the 27701 ISO. If you're interested in that course, let us know. We're also offering it as well. They will show you all of that. This is the recent audits, things, that can further prove that they are compliant to GDPR. You see, they may not be aware with NDPR. All right. And the thing is, see, you cannot go to Azios now and tell Azios to comply with NDPR. They won't listen to you. So the clever thing is, you will do the mapping because they know GDPR. And if GDPR is like for like with NDPR, so it means that they can show you a certificate of compliance with GDPR, then you are happy. All right. Then what you also want to, like I said earlier, is where are the gaps? All right. And if those gaps are there, you now go back to them and say, okay, can you help us to fulfill this gap? That is the practical step, to go about bringing your supplier, especially the cloud service provider, into compliance. Then Ari also mentioned something earlier, which was also very, very key. He's talking about, cloud service provider. There's something we call instances, all right? Instances just mean location, all right? So when you say cloud, it's not something in the head. It just means that they have their data center somewhere. All right. So likes of the big ones, Azios, they have in the UK, they have in Ireland, they have in Africa. I don't know exactly, maybe not in Nigeria, they may have in South Africa, and that is the opportunity that is also afford us as well. Can you imagine the population of Nigeria? We're over 180 billion. Why would Azios have a data center in South Africa and not have it in Nigeria? So if our government are clever, then they can start to have that conversation with them. Okay, we ain't going to do business with you if you can't have a data center here. And then the owner will start to think, hang on a minute, with this population, we're going to lose a lot of money. Then we need to have, the data center in Nigeria. See, listen, we might not be the government, but you can start to have this conversation, with people in authority if you know them. All right, I hope that answers your question anyway. Any question?
Yeah, I think so. Obi follow up with the questions that there's no instance in Nigeria as per AWS. Okay, that is fine. I don't know.
I think they have instance in South Africa. I think they have instance. You see, but you don't have to worry too much about where the instance is. I think we've already answered the question. If GDPR is like for NDPR, and we can prove that from this conversation, then you cannot force them to come and have instance here. I'm not saying that's what you're saying, but I think let's not lose focus, from what we are trying to achieve. What we are trying to achieve is the compliance to NDPR. If they can prove that, then where the instance is, I think is irrelevant. Not that it's irrelevant, because like for companies like, countries like, I'm going into depth now. For companies like Germany, countries like Germany, for example, you can't take their data anywhere. You can't, Ari, you live in Germany, you would agree with me. You can't take their data anywhere. As a matter of fact, their data sits within Germany. That's how stringent their law is, how they protect their company. But I don't think Nigeria is there yet, okay? We should agree that, this is a good starting point for us as a nation. And again, hopefully if this goes well, then other things will follow. All right?
Yeah, I think just to add to this, if you remember when I did the presentation, we talked about transfer of personal data. So where personal data is transferred to a foreign country or an international organization, the data subject shall have the right to be informed. So those businesses in Nigeria will have to inform their data subject that possibly their data is being stored in AWS, and they have to put those safeguards in place, the appropriate safeguards in place to be able to transfer data. Both regulations then say you cannot do that, but you just need to have those safeguards, those data, those transparency to tell your data subject or the individual right to say, we have your data will transfer between AWS, and which everybody in Nigeria know, or not everybody, I mean, some educated people will know that your data sits in AWS and it might not be in Nigeria. But AWS is quite secured in terms of the compliance with GDPR, and then now going to be trying to comply with NDPR, which is going to be an easy task because they already have those processes in place. So it's not going, they're not breaking any law, but it's just left to the organization to inform their data subjects what they're doing with their data, and if they need to have consent or which kind of safeguard they have in place.
All right. Okay. So, Ari, thank you. Is there any other question there?
No, there's not that question. I think.
All right. So, gentlemen and ladies, thank you for your time today. Segun, do you want to say anything?
I don't think Segun is on the call.
Oh, okay. Okay. All right. So, guys, thank you. If you need further information in terms of how we can help you with knowledge around this regulation, we offer various consulting and courses around this. Please by all means reach out to myself. You should have Ari, can you put our maybe telephone number or something? I mean, quite a number of people know us, but let's not assume. Let's say you can reach us. That is our website, Smart Learning. smartlearninguk.com. You can reach us there, and you can also get our telephone number. You can talk to us. My own telephone number is 078-7714-5576. You can reach us on this telephone number if you want to chat and learn more about this particular topic. Again, thank you so much. And also, we will publish the recording. Please bear with us. It might not just be immediate. It takes time. We'll publish the recording and then we'll put it on our website. So if you go to our website under resource, you'll find already published webinars there and things that you can learn from, not just GDPR. A few other things that we have done. You can learn from it. All right. So thank you and take care. Enjoy the rest of the evening. Bye for now.
Thank you, everybody. We'll see you then. Bye.